We're coming on the air because the Supreme Court has just released a major decision which could have a profound impact on the midterm elections. The justices issuing a ruling on a case out of Louisiana involving the Voting Rights Act, redistricting, and whether states must end any consideration of race when redrawing congressional maps. The decision potentially reducing the influence of minority voters and minority representation in Congress. Let's get right to our senior Washington correspondent, Devin Dwyer, who covers the Supreme Court for us. Devin.
Kira, this decision is 6-3, written by Justice Samuel Alito, and it's a significant decision and a setback for the landmark Voting Rights Act of 1965, which was passed to guarantee equality in how we vote, and of course addressing the systemic and historic racial discrimination, especially across the South. This decision came in a case out of Louisiana involving a court-ordered drawing addition of a second majority black district in that state because of the size of the state's population. And the Supreme Court today, in this decision, said that the court violated the 14th Amendment by adding, the state rather, violated the 14th Amendment by adding that district. They used race impermissibly, consciously, to add a second district to aid those voters, and they said that is simply not allowed under our Constitution. Justice Samuel Alito didn't go as far as saying race can never be used in drawing these maps. That's something the court has affirmed before to comply with the Voting Rights Act, but he put a significant new limit on how courts can order states to draw their maps to be more equitable. He said that Section 2 imposes liability only when evidence supports a strong inference that the state intentionally drew its map to discriminate.
The Voting Rights Act now effectively requires proof of intentional discrimination, not merely what is known as disparate impact discrimination, and therefore, since there wasn't evidence of that intentional racial discrimination, that second majority-minority district violates the Section 2 of the Voting Rights Act, the net effect of which is to take the Voting Rights Act and turn it from a weapon against racial discrimination into a much, much less significant version of its prior self.
Back in the 1960s, after years of discrimination, the Voting Rights Act of 1965 was passed with a clear goal: make sure black Americans could actually vote and have their votes count. One of the ways this played out over time was in how voting districts were drawn. In areas with large black populations, maps were often shaped to ensure those communities had real representation. On paper, that sounds straightforward. But here's where things start getting complicated. As the years went on, political strategists on both sides began pushing the limits of how district maps could be drawn, a practice known as gerrymandering. And this is where the tension builds. Republicans started arguing that the rules weren't being applied evenly. Their complaint? Democrats could redraw maps for political advantage, but if Republicans did something similar, and it affected districts with large black populations, it could be challenged as discriminatory. In other words, the fight.
Leah, what do you see as the ripple effects? Are there other states that could now redraw their maps that you think are going to be likely to do so?
It's very possible. So one expert on voting rights, Professor Nick Stephanopoulos at Harvard Law School, actually estimated that a ruling to this effect in Louisiana versus Calais could affect up to potentially 50 legislative districts. Now, that's not to say all of those states might redraw their districts so close to the midterm elections, but that does underscore what a significant effect this ruling will have on our democracy and who is able to obtain political power.
Should election maps ever take race into account, or not at all? Back in 1965, the U.S. passed the Voting Rights Act of 1965 after decades of blatant voter suppression. In many parts of the country, black Americans were technically allowed to vote, but in practice, they were blocked at every turn. So the law didn't just say, let people vote. It went further. Over time, it pushed states to draw voting districts in ways that gave minority communities a real chance to elect candidates, especially in places where their voices had been shut out for generations. For a while, that seemed like progress. But then politics got involved, heavily. Both major parties began using gerrymandering to their advantage, carefully shaping districts to lock in power. And that's where things started getting messy. Drawing districts for political gain is generally allowed. but drawing them in a way that harms a racial group? That crosses a legal line. So the fight became about where that line actually is. Some critics argue that focusing on race in map drawing, even for representation, can go too far, effectively sorting voters and influencing outcomes. Others say ignoring race entirely would erase hard-won protections and make it easier to dilute minority voting power again. That disagreement has been building for years, until it reached the courts. The Supreme Court of the United States has taken up multiple cases on this issue, and its rulings have gradually shifted how these disputes are judged. In some decisions, the court has made it harder to challenge maps unless there's clear proof of intentional racial discrimination, not just unequal outcomes. That shift matters a lot. Supporters say it prevents courts from policing politics and keeps the focus on clear violations. Critics worry it raises the bar so high that subtle forms of discrimination might slip through, and the ripple effects are already showing up at the state level. In Virginia, for example, redistricting battles have gone all the way to the Supreme Court of Virginia, where maps have been challenged and, in some cases, thrown out for not meeting constitutional standards. So what does all of this mean? It means the rules for drawing political maps, something most people never think about, are constantly being rewritten. And those rules quietly shape who holds power, which policies move forward, and whose voices are heard. At its core, this isn't just a legal argument. It's a deeper question about fairness, representation, and where the line should be drawn between the two. And depending on who you ask, that line is either finally being clarified, or pushed in a direction that could reshape elections for years to come.
Court of Virginia has denied a motion from the state's attorney general to allow last week's redistricting referendum to be certified. Thank you for joining us here at midday. I'm Cheryl Miller. Voters approved a temporary change to the state's congressional maps to give Democrats a 10-1 advantage. But last week, a Tazewell County Circuit Court judge ruled that referendum and results were unconstitutional and said the vote could not be certified. The lawsuit was brought by the Republican National Committee. Virginia Attorney General Jay Jones asked the court to put a stay on that ruling and allow the certification to proceed, which was rejected. However, the justices did not rule on the merits of the case itself. Those will be heard at a later date, but a spokesperson for the court says one has not yet been set.
It looked like a big political win, right up until it started falling apart. For a moment, Democrats thought they had pulled off a major victory by pushing through a new redistricting map, one critics quickly labeled as one of the most aggressive examples of gerrymandering in the country. Supporters saw it as strategic. Opponents saw it as overreach. But here's where things took a turn. The way the map was approved raised serious legal questions. Challenges started rolling in, arguing that the process itself didn't follow the rules laid out in the state's own constitution, especially when it comes to how changes are supposed to be made. And that's the key issue, not just what the map does, but how it was created. Even some analysts who generally lean left began acknowledging a hard truth: the case against the map might be strong enough that courts won't have much choice. The expectation? It could get struck down, potentially even unanimously, depending on how clearly the rules were violated. That puts everything back to square one. Meanwhile, the bigger picture is just as tense. Across the country, both parties have already pushed district maps pretty far in states they control. There's an ongoing debate about how much room is left to redraw lines in a way that meaningfully shifts power. In a competitive state like Virginia, even small changes can have big consequences, which is why this fight mattered so much in the first place. But if the courts block the map, that opportunity disappears. At the same time, attention is shifting elsewhere. In Florida, new maps backed by Republicans have already reshaped districts in ways expected to benefit them in future elections. Supporters call it fair play within the rules. Critics argue it raises many of the same concerns about representation and balance. And that's the pattern repeating across the country. Every time one side pushes the limits, the other responds. Every map becomes a legal battle. And every decision, especially those influenced by courts like the Supreme Court of the United States, reshapes the playing field just a little more. So what started as a single redistricting fight in one state is really part of a much bigger story. A story where the lines on a map aren't just geography, they're power.
And the Supreme Court has cleared the way for Texas to use its newly redrawn congressional map this November. In a 6-3 decision, the justices struck down a lower court's ruling that blocked the state from using the map in these upcoming midterms. The new congressional lines could flip 5 Democratic U.S. seats to Republicans. Actually, the Texas House Minority Leader released a statement on behalf of the state's House Democratic Caucus, arguing the Supreme Court did not protect the Constitution. Instead, it protected a, quote, racist map, they say, that stole seats and weakened Black and Latino voting power. That decision comes as Florida makes its own moves. Florida Governor Ron DeSantis sharing his proposal to redraw the state's congressional districts, a move that could give Republicans as many as 4 new seats in Congress. DeSantis unveiled his new map yesterday, part of a national redistricting fight President Trump and Republicans kicked off last year in an effort to improve Republican chances of holding on to power in November, which are under threat, according to recent polling. The map shows in Florida 4 blue districts for Democrats and 24 red for Republicans, up from 20 Republican in Florida's current delegation.
After the court ruling started shifting the ground on redistricting, reactions came in fast, and they weren't subtle. Prominent Democrats warned that the impact could be far bigger than just a few maps changing. Ilhan Omar argued the decision weakens core protections tied to the Voting Rights Act of 1965 and could open the door to voter suppression. Barack Obama went further, saying it risks allowing lawmakers to redraw districts in ways that dilute minority voting power, so long as it's framed as partisan, not explicitly racial. And Gavin Newsom warned that changing the rules around district maps could silence key voting blocs and reshape elections in a lasting way. That's one side of the reaction. On the other side, supporters of the decision see something completely different. They argue this is about restoring balance, making sure the rules are applied consistently and that courts aren't deciding outcomes based on political effects alone. To them, it's not about weakening protections, but about clarifying where the legal line actually is. And that's the real turning point in this entire story. For decades, the fight over maps often came down to results: who benefits, who loses, and whether certain groups were being unfairly impacted. Now, the focus is shifting more toward intent, what lawmakers were trying to do when they drew those lines. That might sound like a technical detail, but it changes everything. Because proving intent is much harder than pointing to outcomes. And that means fewer maps may get blocked in court, even if they produce uneven results. So where does that leave things? Right in the middle of an ongoing political tug-of-war. States like Virginia and Florida are already battlegrounds for these changes, with each new map sparking fresh legal challenges. And hovering over all of it is the Supreme Court of the United States, continuing to shape how these rules are interpreted. But here's the bigger picture, stripped of the noise. This isn't just about one party winning or losing. It's about how a democracy decides what fair actually means. Should maps aim to reflect communities as they are, or should they be drawn without considering race at all? And who gets to decide when the line is crossed? Those questions aren't going away anytime soon. What is clear is that every ruling, every map, and every reaction is raising the stakes, quietly but significantly, on how elections will look in the future. And depending on where you stand, this moment is either a correction or a warning.